We're in recess about 20 minutes.
I have a motion. I have a motion.
In regards to what, sir?
Your comments. I have a motion.
Okay, what's your motion?
Buckle up, guys. Today we are going to witness a courtroom confrontation that explodes the second recess begins. Defense attorney Mr. Steele immediately challenges the judge, accusing him of publicly humiliating him in front of the jury for a second time. What starts as frustration over evidence handling quickly turns deeply personal, as Steele insists he was fully prepared and claims the court's remarks unfairly damaged both his professional credibility and his client's defense.
This is the second time that this honorable court in front of the jury has addressed me inappropriately and wrongly. Second time. The first time I gave the state discovery of a song from a Super Bowl. Weeks before, there was an objection. You assumed that I didn't give it to the state. I didn't want to embarrass the court. So you were yelling at me and saying, do you understand me? Do you understand me? And instead of saying, do you understand that you're wrong? I sat here and I said, yes, Your Honor. That was to protect the integrity of this courtroom and the court. Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
Okay,
I have no. I need to make a record. Your Honor,
Mr. Steele, wait a second. When you keep delaying, okay, and that's what's happening to the court. You keep delaying and elongating and pushing out these particular our ability to present a seamless case in front of the jury. That's my purview as a judge. And I've asked you a number of times, you and your colleagues on both sides, to go ahead and listen to whatever it is you need to do, prepare me as needed. Now, I asked you those two particular questions because if they've turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection. And I was trying to solicit from you whether or not we could just go ahead and just hear it. So you can imagine my frustration because all these little delays just elongate out our presentation in front of the jury. That's for your benefit, not for mine, Your Honor. So that's why I've told you all at various times during this particular case. It's not because I want to embarrass you, Mr. Steele. It's just that I'm trying to kind of keep this thing presented in a way that the jury can listen to it.
And the court is wrong. What happened was, let me finish, and I'm making this for the record. What happened is, and I don't get embarrassed by you, but I don't want to embarrass you. I made an objection that some of these jail calls have a third party who will not testify. I objected to hearsay. The state said it explains the effect.
Okay, which call? Which call?
These calls, as you...
Okay, well then why aren't we taking them up beforehand?
The state just said, just now, these are the 3 additional calls that they want to introduce.
Okay, all right, well, then here's your response. I'm going to give you an acceptable response.
Well, I'm going to make my motion.
Huh?
I need to make my motion.
Judge?
The judge pushes back, explaining that repeated interruptions and unresolved objections are dragging the trial down and frustrating the jury's experience. From an outside perspective, this becomes a battle between efficiency and legal advocacy. Steele argues his objections were valid hearsay concerns involving jail calls and unavailable witnesses, while the judge maintains those matters should have been resolved earlier instead of stopping courtroom momentum.
There's more to this than we need to listen to these calls.
Right.
Then I would have no, you didn't say that though. So I wouldn't have had that opportunity. But that's why I keep telling you this, okay? I mean, like I told you, forewarned judge, a happy judge. All right, so had you just told me up front, Judge, we have not had the opportunity to listen to all of those calls. We've only been able to listen to 2. I want to listen to the other ones. And
I've listened to the calls. I know. I don't know what the third one they're trying to do.
Okay, well,
listen, let me just finish. So you presuppose I don't know what the calls are. Well, I don't know what the third call is because Ms. Hilton, who's professional, said, I'll take a break and I'll let you know what it is. But the other 2 calls are the baseball game and at a chicken, discussing chicken wings. or chicken. I understand those calls. There's issues in those calls that you need to address. But I politely make an objection and say, Your Honor, based upon what you told me, which is what you told me, we'll take it up later. I wanted to raise it. You tell in front of the jury how unprepared I am. And let me tell you something. I am not unprepared. I don't appreciate the court telling me that. And you don't, and I asked you, tell the jurors that you were wrong when you admonished me last time. You said you wouldn't do that. This is the second time. And you know what it does to me? I don't care. I'm hurt because you're a court, but I really don't care. But what does it do to Mr. Williams?
Mr. Steele, I'm not trying to personally insult you or hurt your feelings, okay? You are a grown professional advocate. I am a grown professional jurist. And people say things to me that border on the lines of I could take action or not. You have certainly said some of those things to me during the trial of this case. I have let them go. So, sir, that's just the trial. That's just the trial of the case, okay?
No, but that man's life is here.
And you know you're doing a fine job in representing him. Well, but you know what? That's just the way we are right now. But the crux of the issue is, Mr. Steele, and the representatives from the state and everybody else. What happens right now is I have to take a break in order to vet all of these issues, which I'm required to do, Mr. Steele. And that's what is kind of disappointing to me, because I have given you all this administrative time, all these breaks to go ahead and do this, and this is what delays the presentation of this case in front of the jury.
You know, if I would have done what the state did, and I'm not poking anything at Ms. Hilton, you would have said to me, why didn't you share those calls with him before? You were out all day today. We didn't start court till 1 o'clock. I would have shared them.
I know you would have.
But the state didn't. I'm not poking fun because I can deal with it. But when the court then steps in.
But here's the problem. I have a problem with it because at the end of the day, I got to listen to a 15-minute call.
You don't have to listen to anything.
But
you have to make a ruling
yes,
on it.
But I have to listen to it in order to make the ruling on those. And even if you said you've listened to the chicken call and the baseball call, and if you say there's other issues that come into play, it's better for us to take those things up before I ask for that jury. And I could have done that this morning. I could have done that at another point in time. So, I mean...
Well, I raised this issue to you, and I don't remember the date, but it was days ago. I raised it, and the court said, all right, understood, and we'll take that issue up when it comes.
Okay.
What am I supposed to do?
Okay.
Sit there and say no objection?
No,
exactly right.
Not at all.
I said, Judge, it's an issue we need to take up.
Not at all.
And in addition to that, today alone, and this happens, today alone, the state introduced 2 exhibits. I've never been given them before, ever. You know what I did? No problem. No problem. Because I think that's professional. One was a Google map. It needs to be clarified for the record that it was not done on September 11, 2013. And then a map with little dots with 0.4 miles I've never seen before. But I didn't do anything, Your Honor. I want to move the case. But when the court, it gives me no pleasure in saying this. I believe that this honorable court is biased.
Now the tension escalates sharply. Steele points out that the prosecution introduced materials he says he had never seen, yet he stayed silent to keep things moving professionally. But then he makes his most explosive accusation yet, saying the court appears biased against either his client or defense counsel. From an observer's perspective, this changes everything. The dispute is no longer procedural. It becomes a direct challenge to judicial impartiality.
Bias against Mr. Williams and or his counsel. And I ask you to consider recusing yourself, or don't do this again to me. This is inappropriate to me. I respect you, but what am I supposed to do? Sit there while you do this? I didn't do anything wrong. I did exactly what you teach me to do and the courts teach me to do.
All right.
But instead, no, I got to finish this. Then I get told to this court says by Prosecutor Love that I'm not being candid with the court and I'm misrepresenting because Mr. Bean never went to the hospital at Grady on September 11, 2013, and Ms. Love has a document on the desk to prove it. I sat right in front of Your Honor at the table, at the bench, and I said, I'd be careful what you say. That's not accurate. Ms. Love looked down on me and she said, it is accurate. You said, we'll take a break, figure it out. After the break, you didn't even bat an eye. Ms. Love said, yeah, I was totally wrong. Mr. Steele's right. He was taking a Grady. If I would have done that and called another member of the bar disingenuous, not truthful, no candor, and misrepresenting, you would have had me yelling in front of a jury. You did nothing. You didn't even ask Ms. Love to apologize. I don't want her apology. I don't care about Ms. Love, but I care about the court. And now if you can walk in someone else's shoes just for a minute and see what you're doing to Mr. Williams, because it's hurtful. I'm not the one wasting time. I'm here every day ready to go. I am not wasting the time. I make a motion to ask you to please recuse yourself. I know it has to be in writing within 5 days. If you want me to do that, I'll do it, and that's to go to another judge. But this is what's going on, Your Honor, whether you see it or not. You're yelling at me in front of a jury for nothing, and then you won't apologize. And I did nothing wrong ever on these occasions or others.
I'm going to go ahead and address your motion at this point in time. I'm going to deny your motion at this point in time.
The judge denies the recusal motion, insisting heated exchanges are part of courtroom litigation and not proof of bias. But Steele refuses to let the issue go. He brings up previous incidents where he believes prosecutors were allowed to make damaging accusations against him without consequence. Watching this unfold, the argument shifts into a much larger conflict about unequal treatment, credibility, and whether both sides are truly being held to the same standard.
And also just direct you that I had the responsibility to control the proceedings in this particular circumstance. Sometimes things get kind of heated, and that's that's the crucible and trial of any particular case. I am not in any way intimating or insinuating that you are not professional, you are not prepared, but the things that I am bringing up to both of you, and I have fussed at both sides for this particular issue of not being prepared in the sense of, and the only reason it affects the trial of the case is it makes the proceedings a lot longer than they should be, because all these things could be taken up. And sometimes if we've got to parse out all these things, as you can see right now, it takes time, and that's what I'm kind of concerned about, having been a jurist for a long time. So, I understand that you're a zealous advocate. You in no way offend me by raising any type of motion. I think you're doing I think that you and the others here are representing your clients well, but sir, I have to be able to control these proceedings. And you at times in these proceedings have not listened to what the court's told you, and I certainly could have explored other options. I didn't. So, I'll tell you that much, for what it's worth.
You allowed a member of the bar yesterday ask a witness who constantly is committing, respectfully, potentially perjury. Did Mr. Steele shut off and turn on the recording? I never did that. I wouldn't do that, and I didn't do that.
Okay, and but sir,
I would have said that question about another member of the bar, prosecution. You would have come over the bench and said, "How dare you?" I sat there and I said, "Outrageous." You denied the motion. I think 3 other people made motions to strike or to object. You denied it. Judge, I'm just telling you, the appearance, if not the reality, is not good here. I'm being...
What, to who?
To Mr. Williams.
Okay, but...
Maybe to the others. Maybe
you're his advocate, okay? And that separate issue of whether or not you did what you did, the state accused you of that, they have the right to at least inquire about whether or not that happened. Now, whether or not it happened or not, I'm not making any comment on it, but it goes to bias, it goes to motives to misrepresent. But
never happened. No good faith.
Okay, but I'm not commenting on that. That's for the jury that's for the jury to decide.
I asked the question about a missing recording that I wasn't given of a statement made by Mr. Bean. And you know what you told me?
And I keep telling you.
You know what you told me? You said, does the state have it? They said no. You said, nothing I can do. I tried to cross on it. You sustained an objection.
Because it doesn't exist at this point in time. Now, if it exists at some point, I told you I'd say it. One, I tell you, I apologize to you, and then two, I'll take corrective action against the party or the entity that failed to give you that particular statement.
But the point is, everyone knows he spoke to the detective
But
beforehand.
we don't. That's
He
the whole
said
thing.
it.
You believe it. You honestly believe it, and that's true.
On September 17th, 2013, on recording, Mr. Bean tells that to Detective Quinn. How is that far-fetched? Why would he ever say that? I lied to the other detective.
The courtroom clash reaches another level, as Steele argues. The prosecution was permitted to suggest serious misconduct, including possible evidence tampering, while he faced criticism for far less. The judge attempts to separate advocacy disputes from judicial neutrality, explaining that factual credibility issues belong to the jury. But from a third-party perspective, the disconnect is obvious. One side sees procedure, the other sees prejudice.
Why would he ever say that? I mean, logic has to come into this courtroom at times. But you stop me from doing it, but you allow another lawyer make up that I'm stopping and starting a recording. And he says, well, I don't recall, I don't remember anything.
Here's the thing, that's why probably Miss Love asked me to put it under seal for the time being, but I mean, I'm not saying anything, but if true, that's a pretty serious accusation.
If true, I'll die right now. How about that, Judge Glanville?
Your Honor, I object to this.
I don't care about her objection. I'm speaking with the
Your
court.
Honor, I object, and
I'm
I'd like to
speaking
level
with the
an
court.
objection.
Okay.
I'm speaking
Let
with
him
the
finish,
court.
and then you can state your.
My point is, if you don't see what's going on, it's because you're not viewing it out of the lens
But
of
Mr.
a juror.
Mr. Steele, I can't do that. I have to be the referee. So the jury decides those particular issues of believability and credibility. Now, I'm not getting into the throes of war between you and the state. That's your business, and that is certainly
nothing to do with a throw war.
No, but I mean, it's your ability as an advocate. I told you before, that's your ability as an advocate. All right.
What I'm saying is, you said in front of this jury, I was unprofessional. I am not unprofessional. You were wrong.
I think at that particular point in time, given the totality of what happened, that's what the court's assessment was. Sir, I am.
But it was wrong.
It's a snippet in time. Mr. Steele, you're a very good attorney, but I'm a professional jurist, and you may not like some of the rulings that I make, and you may not like the way that the trial is going at a particular point in time. That's for all advocates. Ms. Love and her colleagues, I've told them the same thing. But I think that, my job as the referee is to give you a fair trial. And that's what I'm going to do.
Well, I hope that's true. But you just told the jury I'm unprepared. And I am prepared. I don't understand why you would say that.
Both of you, and I'll level this against the state. Both of you, that's being unprepared, because that I have to then listen to this to rule on it.
I understand, but I'm the only one that the jurors here, the court, take ire with. Ever. Without an apology, without telling the jurors.
I think I've taken Ms. Love and Ms. Hilton and her colleagues to task many times.
No, I've heard you yell at them.
I've taken them to task as well.
I've heard you say to her, stop interrupting me, answer my questions.
That's taking them to task?
The jurors never heard that. Ever.
In the final stretch, Steele returns to the original wound, the judge's public statement that made him appear unprepared before the jury. He argues that regardless of intent, the damage has already been done to his client's right to a fair trial. With tensions completely maxed out, he formally requests a mistrial, transforming the confrontation from a heated dispute into a direct challenge against the legitimacy of the entire proceeding. Like the video, subscribe to the channel, and we'll see you in the next video.
Ever. So I ask for a continuing recusal motion. And I know it's not in writing, but I assume that you're ruling on it right now. That's what you're saying.
Well, one, you got to put it in writing, but I mean, I'll rule on it at this point in time. I'm going to deny the motion, but you need to put it in writing if that's what you wish to do. I'll appropriately.
I'm also asking for a mistrial based upon your statements. I think I made that clear, but I'm asking for a mistrial.
Okay, now, Ms. Love.
I don't think it's a fair forum for Mr. Williams.
Okay.
And I don't want to ask for a mistrial, but I have no choice when the court is saying what it said, and I'm not going to repeat it in front of a jury. That's hurtful. And I'm not saying me. I mean, regardless of what I think of it, it's hurtful to Mr. Williams getting a fair trial.